Buckle up, guys. Today we are going to watch a defense strategy that starts with a risky admission. Right out of the gate, the attorney doesn't deny the act. Instead, he leans into it, acknowledging that the defendant caused pain. But then comes the twist. He quickly pivots to describing him as hardworking, responsible, and not a threat to society. It's a bold move, trying to balance guilt with character, and it immediately sets up tension.
And did he have the intent to touch her that caused pain? And did. He did that. Now he's guilty of it. So, I know that if he's not in jail, I know that he's able to work and be successful and take care of himself. He's not been a drain on society in terms of that. He's not a lazy man. He's not a stupid man. So I think when he's not in relationships that he should not be in, and this had nothing to do with drugs or alcohol, he's just a good person, and he means well and he does well. And this was not a relationship either. There was not a relationship between these two. That was more of a working thing.
That's what's weird, is because in the criminal complaint, the probable cause, which comes from the police report, it identifies her as a girlfriend. It identifies her as something over a period of time, where this could have been something what could have occurred over multiple other incident dates.
And I suspect that I'm just suspecting when Attorney Renicky was going through this and charging this out or whatever, maybe he had contact with the victim in this case, and maybe she also said, I was not in a relationship with him at this time period.
Well, and I will go over to the district attorney now to ask from their perspective, because I'm going to say quite clearly in the criminal complaint, which comes from the police reports, which comes from their investigation, which comes from the statements from the witnesses and the victims, it states she is the girlfriend. It states.
Now things start getting murky. The narrative shifts to the nature of the relationship, and suddenly, what seems straightforward becomes complicated. The report labels her as a girlfriend, but the defense hints that this might not be accurate. This is where the case begins to blur, because if the relationship isn't what it seems, it could influence how everything is interpreted moving forward.
On September 6, 2024, I, Deputy Henry, was requested by dispatch to respond to. Dispatch advised that probation agent Lineweber was at the residence looking into allegations that Bradley Scheuer assaulted his girlfriend, JEC, last night. And if you go down, it says in the middle of the paragraph that she was worried about further retaliation from Bradley, as he told her numerous times that he knows people and he can hurt her even if he's in prison. And where else did it say? He threatened to burn her alive in the camper. Where else does it say other things like that? But
the defense agrees that that's in the complaint, but again, I don't think that she's saying that she was in a relationship with him. The only thing that I had read from it is they were investigating allegations that Scheuer assaulted his girlfriend.
Schmidt?
I'm the one who charged it. The reason it doesn't have the domestic abuse surcharge is boyfriend, girlfriend is not something that creates the domestic abuse surcharge in Wisconsin. It's whether they're married or reside together or have children together. Being boyfriend and girlfriend does not make it a domestic abuse offense in Wisconsin. That is why I did not.
Well, and quite honestly, whether or not he's guilty of the charge and how it is charged doesn't really matter if it's boyfriend or girlfriend. Well, granted, if it is a girlfriend, you probably should care for that person and not want to harm them, but you shouldn't want to harm anyone. So, Mr. Davis, I don't know. I don't know if it's a girlfriend. I don't know if it's not a girlfriend. I don't have the victim here. I don't believe in court here today. I just know what was reported to law enforcement. And I don't believe that law enforcement would make something up and put that in a police report. And
now pay close attention, because this is where the tone darkens. The judge starts reading directly from the complaint, and the details are disturbing. Allegations of threats, fear, and intimidation come into play, painting a far more serious picture than the defense suggested. What was framed as a single incident now feels like part of something much more dangerous and ongoing.
That's where we get the criminal complaints and the information from.
Well, just
law enforcement.
In my argument, Judge, my client was not in a relationship with her when this occurred. And it's my belief that I think that she did live in Minnesota too at the time. They were not residing together. At least that's That's what I believe. And so I don't believe it was a domestic relationship as defined by the statute. But in any event, I'll concur. I don't care if a person's in a domestic relationship or not. If you touch someone without their consent and it causes them pain, it's a crime, and it doesn't make it any, well, I guess I agree with you a little bit on that too. I guess if you're in a relationship with somebody, there's a tie where you wouldn't want to hurt that person, but still, it's not good, and it's why there's a law, and that's why now he's convicted of a misdemeanor because of it.
And I'll also point you to page 3 of the criminal complaint where JEC also stated there have been times while they were staying at her residence in Minnesota where Scheuer has struck her, but she has never reported it. JEC stated when Scheuer had kicked the front of her knee last night, he told her that it only takes 10 pounds of pressure to break it, and she will not be walking out of there. She would be crawling out.
And again, I think the criminal complaint in Wisconsin, they're mere allegations. I think in the discovery, or if you get body cam footage, or you get also stuff from the victims writing in themselves, a lot of the times, I would say most times it's different from what's in a criminal complaint.
I'm just pointing to the fact that JEC was saying that there was some type of relationship, whether or not
Doesn't give a.
Here's where the legal debate intensifies. The discussion shifts into technical territory, what qualifies as a domestic relationship under the law. The defense tries to separate the emotional aspect from the legal definition, while the judge keeps bringing it back to a simple truth. Regardless of labels, harm is harm. It's a clash between legal nuance and moral clarity.
A time, but I'm just saying, I don't believe that this was a domestic relationship as defined by the statute. But in the state has not charged him as such. But in any event, going forward, Judge, he's got the 164 days that he's sat. I know that I think the jail does have an effect on most people. I've had clients where they don't really care. Bradley does care. I know that he's climbing the walls. I know that he'd rather be out working and just doing normal things that people do out in the community rather than sitting inside the jail cell. And so for that, I think this has affected him. Again, I've got clients where they really don't care. Jail doesn't scare them. A prison doesn't scare them. But in this case, Bradley, it does. And so I'd ask the court to consider that 1 month to the 3 month. I'd ask that be time served on that. And again, probation, it's not that I don't think probation is, I mean, it's not, I don't think that probation is not a good thing in this case, but with regard to for drugs and alcohol, I think that certainly I think probation is important. People can have some kind of monitoring, and I think they can also get involved in a lot of treatment, whether it's inpatient or outpatient through the probation agents. But in this case, he's never going to be having contact with JC again. In that whatever relationship the court wants to think that is, there will never be a relationship between those two. And for that reasons, I'd ask the court to consider my argument. Thank you very much.
Now we see the defense making a final push for leniency. They highlight the time already served, the psychological impact of jail, and the idea that this defendant is not someone who thrives behind bars. It's an appeal to empathy, suggesting that the punishment has already done its job. But whether the court buys into that argument is still very much up in the air.
Thank you, Mr. Davis. Mr. Scheuer, I'm now going to give you an opportunity to make any statement that you wish to make. You don't have to make a statement. You don't have to say a thing, but it's your only opportunity to clear anything up, to let me know anything about yourself that you wish for me to know, fill in gaps, fill in holes, whatever you wish to do. But again, you do not have to make any statement if you do not wish to.
I don't know if you ever read this statement. I wrote a statement of all the work I've done for her when I was at her house. I did a lot of work for her. My job for her was.
I'm going to stop you right there. First, I don't believe that was filed with the court, so I have not read it.
Okay.
Second, you just need to speak a little bit slower. My court reporter takes everything down, and it's very hard to take things down when we speak really fast, okay?
You can read it if you want. It's your.
Well, that looks like a lot of words.
Yeah, I don't know, I could give it to the courts,
And
but
here's the question though. What relevance does it have what work he did for this individual?
Judge, I just think he wanted to impress upon you that the relationship was that of a working relationship. I think again, I think we've
Again,
already got to the
what relevance
point.
does that even have?
Well, I think it does because the court brought up on multiple occasions that,
I'm just bringing up what's been alleged in the criminal complaint and how it was portrayed by JEC to law enforcement and how it was placed in the police reports. And Mr. Scheuer was asked at the date of the incident as well, and he didn't state counter statements to that fact. And then it was charged that way.
Judge, I'm not going to get involved. It says allocution. I really don't know what the,
This is a crucial turning point. The defendant finally speaks. He tries to explain his side, talking about the work he did and the dynamic between them. But instead of helping his case, his words begin to raise more questions. The judge interrupts, trying to steer things back to relevance, signaling that this explanation might not be landing the way he hoped.
I don't know what the limits are on an allocution, so I'll just stay out of that.
He can tell me anything he wants to know, but I don't need to be read every time you've done work for JEC and what it was. If you've done a lot of work for JEC, you can let me know you've done a lot of work for JEC and give me an idea of what it is you did for her.
I did a lot of work for her. I put up garage doors, put up garage door openers, cut down trees because I was supposed to roof her house. The whole key was to roof her house. That was the whole key of that, because she was dating my best friend. That's how I met her. She was with my best friend. That's how I met her. And then I went over to roof her house and I told her I wouldn't roof it until I cut down all these trees. And I cut down some pretty big trees. And otherwise, that's about all I got to say. But a lot of things she did when I was there, she would get upset. Wrong word, whatever. She would get upset at you. And I've had her throw oil on me. I've had her throw water on me. I've had her get mad. She get mad if you said the wrong word or did the wrong thing. She abused me with a fence post. And I got pictures of that.
So did you ever sleep with her, have sexual relations?
Yes.
Yes, so that answers my question. That's all I needed to know with regards to girlfriend, no relationship, no relationship. Doesn't matter if she was dating your best friend or not, you slept with her. So it means to her that you had some type of relationship.
Yeah,
closer
sex buddy.
than just, because I'm gonna tell you, I don't sleep with my roofing guy. I don't sleep with the guy that fixes my garage doors.
Now this is where everything shifts dramatically. In just a few moments, the defendant admits to having a sexual relationship with the woman. That single admission completely undercuts the earlier argument that there was no real relationship. You can almost feel the courtroom energy change as the judge immediately locks onto that detail and reframes the entire situation.
So it means that it was a little bit different than just a hired hand. All right. But anything else you want to let me know?
No, I'm good.
Okay. So all I heard there was excuses, blame the victim, victim blaming, more victim blaming, and excuses. That's all I heard from you, Mr. Scheuer. I didn't hear any remorse. I didn't hear anything about that you're sorry that this happened. You should have never laid your hands upon her. No matter what, I'm going to tell you, even if the sky was purple and grass was blue and she got mad at everything that you did and she threw a brick at your head and caused you a concussion 6 months ago, even if she did that, okay? You had absolutely zero right, zero legal right, zero moral right, ethical right, all the rights to lay your hands upon her on September 6, 2024. Doesn't matter what she did or didn't do prior to that date, you had no right to touch her in any way, shape, or form. You had no right to lay your hands upon her. And some of these statements that she stated that you told her to law enforcement, OMG, like they are out of this world crazy.
Here comes the moment of reckoning. The judge doesn't hold back, calling out what she sees as excuses and victim blaming. There's a clear frustration in her tone as she emphasizes one key point: nothing justifies putting hands on another person. This isn't just legal anymore, it's deeply personal, and the judge makes that crystal clear.
A crazy man says those things. how much pressure it takes to break a kneecap, and that she will be walking. What else did you say? I read it on the record already. These statements, these are more than just threats of harm. They're threats of egregious harm, more than substantial harm, malice, total torture. And you have no remorse. And you're not even looking at me right now. You're looking some other way because you're pissed off because I am telling you like it is. And you're mad because you wanted it to go your way. You wanted it to go your way. And it doesn't matter. It truly doesn't matter in the scheme of life and in the scheme of the legal realm, whether or not she is your girlfriend, or if she is a friend, or if she is a person on the street, or if she is somebody that hired you. In the sense of the legal word, you had zero right to place your hands upon her and to batter her. No right, but you did. Now, so that makes this serious. The fact that you have the criminal history that you do, you have an extensive criminal history, you have a crime that you're going to be sentenced for, not today. I'm not sentencing you today on that. For one, because you don't have an attorney, and you probably can apply for the public defender now since you are in custody. You don't have a job. I don't think you have income coming in. So you probably will qualify. And you need an attorney because the recommendation is prison. So that could be scary. And the second reason is because I think you need some time to let everything sink in, because this is serious. The other crime in the 23 CF 213 is significantly more serious because someone died. And you sit there cocked back in your chair like it doesn't matter. And you have an attorney who's excellent, by the way, who's excellent. An excellent attorney can't get the most guilty person out of the charges. Because you don't just catch charges, you commit crimes to get those charges. You committed crimes to be charged with these criminal acts. I have to look at the community and protecting the community. And Mr. Schmidt was dead on the money when he said, 3 days, I sentenced you to probation, and 3 days. Within 3 days, you committed these crimes. And you're reading something, and Mr. Davis, I don't like that you're writing stuff to him while I'm doing it, or whatever's happening, because he's not paying attention.
I'm paying attention. I can hear.
No, because quite honestly, people can't really multitask. You can't read and listen at the same time. It's proven. All right. So this is important because this is your life. So I don't know what is more important than incarcerated, or whether or not you can walk free, or whether or not in another case you're going to go to prison, or whether or not you can have jail, or what's going to happen here and there. Because this moment is important. It should be the most important moment of your life.
Now the stakes rise even higher. The judge brings up the defendant's criminal history, including a far more serious case involving a death. Suddenly, this isn't just about one incident, it's about a pattern of behavior. The courtroom tension builds as it becomes obvious that this history is going to weigh heavily on what happens next.
3 days. It took you 3 days on probation. before you were arrested for these charges. Okay, Mr. Davis, I don't know what that is. Can you please turn it around because he's not paying attention.
Sorry, Judge, I didn't write that. That's not my writing. But no, I don't know what I was just looking because it was there, so I'm
I don't
sorry.
know what it is. If it's a statement and he wants to read it, he can surely read it and I will wait and I will hear.
Oh, it's not a statement.
Because this is extremely important. And I believe it's important. It's important to you. It's important to me. It's important to the state. It's important to the victim. It's important to the entire justice system. Is there anything that I need to know?
No.
Because you have the floor.
If there's any additional thing you want to say, you can say it now.
No, I'm not
Well,
saying nothing.
apparently whatever
Obviously,
on
she's
that
right, I'm
yellow
wrong.
paper is more important than hearing what's going to happen in his case. So in 23 CF 213, which was a very serious matter in which an individual actually did die and a firearm was involved, the court placed you on probation with a withheld sentence. Within 3 days, you were arrested on these allegations. Within 3 days. And then you were in custody within 3 days of being on probation. That doesn't bode well for your case. And the fact that you're not taking this seriously, you're not showing any remorse, that you're blaming the victim, it's not telling the court that you are taking this seriously and that you are accountable. So based upon all of that and with the totality of everything involved in this case, with regards to count 3 battery, the court is sentencing you to 9 months of incarceration consecutive to any other sentence that you will serve. $443 in fines and fees. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. If you fail to pay your fines and fees, not only will you have a civil judgment entered against you because you're always going to owe it, but I will issue a warrant and you most likely will sit up to 6 months in jail for not paying. I need your DNA. The jail will make sure that they take your DNA with this criminal charge. You may be able to have it expunged from the system through a written letter to the Department of Justice. That is to the Department of Justice, not to this court. This is not a felony. This is a misdemeanor. Mr. Schmidt, what am I missing?
We'll just ask Lieutenant Mangan to get us the credit. We'll submit it to the court, and if there's any disagreement, then the defense can file a motion. Does that sound?
Well, I believe
Agreeable.
that Mr. Scheuer believes it's 164 days. I will give 164, and I will give Mr. Davis 7 days to get any different number.
Works for me.
The 164 days credit. Mr. Davis, what am I missing?
Nothing, Your Honor. Nothing further, Your Honor. Thank you very much.
All right, thank you. Then we are adjourned on that matter. I'm going to call the other case. We are setting it for a different date and time. I believe that for all purposes, it's necessary.
Your Honor, may be excused now.
You are excused.
Thank you.
Yes. We will go on the record in the matter 23 CF 213, State of Wisconsin versus Bradley Scheuer. The state appears through District Attorney Kevin Schmidt in person. Mr. Scheuer appears in person in custody without counsel. We're set here today in this matter for a sentencing hearing on revocation. Mr. Scheuer was convicted of possessing a firearm as a convicted felon, a G felony. He was placed on probation with a withheld sentence back on September 3rd, 2024. He was arrested on new charges in which he has just been sentenced just recently today. He was placed on probation and was on probation for 3 days before he was arrested on new charges. He was revoked on this case and these charges. The court has received a revocation order and warrant packet. It does recommend a prison sentence. Mr. Scheuer does not have counsel. Mr. Scheuer, this is a serious case and a serious matter. I know that you indicated that you wish to represent yourself off the record. However, this again is a serious case with a recommendation for prison. Therefore, I would strongly encourage that you contact the public defender's office and you apply to see if you qualify. You have been in custody for a significant amount of time. Therefore, you may qualify for a public defender. I'm going to reschedule this matter for a different date and time to give you an opportunity to see if you qualify. If you do not qualify, then you can apply for a court-appointed attorney, and one could be appointed to you with a deposit. You have done that previously, and your son has put down a deposit for you. Again, this is a very serious matter with a recommendation of prison. So I'm going to give some time. I believe we need at least an hour. The closest I can get it in is March 24th at 1:15 on a Schmidt week, because I'm leaving it on a Schmidt week, correct? Or am I okay to place it on an ADA week?
Either works for me. I think either of us can do it.
Okay, so then let me look.
Whatever's convenient to the court.
How about March 17th at 10:30? March 17th at 10:30, that's an ADA week. That gives you plenty of time to apply for a public defender. Again, if you do not qualify, you can apply for a court-appointed attorney and have a deposit, and one would be appointed to you. Thank you. We are adjourned.
This is where it all comes to a head. The judge delivers the sentence, 9 months of incarceration, along with fines and additional consequences. But even after that, the story isn't over. Another serious case looms in the background, with the possibility of prison still on the table. This ending leaves a lasting impact, showing that actions have consequences that don't just disappear. If you found this breakdown insightful, make sure to like the video, subscribe to the channel, and we'll see you in the next video.